Paris, the U.S. Supreme Court announces it will take up a major case that some say could threaten abortion access across the country. The court will hear an appeal supporting a Mississippi law so far blocked by lower courts, which would ban most abortions at the 15th week of pregnancy. The decision comes as the court wraps up oral arguments in several cases involving free speech online, financial disclosures for charity donors, and more. Here to help us break it all down are Aziz Huq, a professor at the University of Chicago Law School and former clerk for Justice Ruth Bader Ginsburg; Robert Hochman, co-lead of the Supreme Court and appellate practice at Sidley Austin, that's a law firm, and a former clerk for Justice Stephen Breyer; and Joseph Morris, a former Assistant Attorney General under President Ronald Reagan and attorney at the law firm Morris and De La Rosa. Gentlemen, thank you so much for joining us. Aziz Huq, this Mississippi law, which again would ban most abortions at the 15th week of pregnancy, do you see it as a challenge to Roe v. Wade, potentially?
Yes, the Mississippi law on its face is inconsistent with Roe, and more importantly, a 1993 case called Casey, which limits the state's authority to regulate abortion before the point of viability, which is between 23 and 26 weeks into the pregnancy.
So, Joe Morris, what does it tell you that the court has taken a case which could conceivably have reverberations that might impact Roe v. Wade?
Well, that's right. It's an important case. There is an entire spectrum of possible outcomes here. At one extreme, the court could attack the foundation of Roe versus Wade itself and overrule the proposition that this maternal right to an abortion is found in the Constitution. But there are any number of shadings of possible outcomes between there and where we are now. The narrowest a narrow way to frame the question here is, what's the meaning of the trimester regime and the viability standard, a completely judge-made standard grounded in no text of the Constitution or any statute? Is it possible for these judges to tweak the work of those judges and to say that it's possible for a legislature, by enacting a statute, to define the limits of the notion of viability?
Robert Hochman, do you see viability as a potential inroad into Roe v. Wade? That is to say, when a life begins.
Well, I think that's sort of essentially the question here. I don't know whether it's about when life begins exactly. I don't think that justices are going to wade into that kind of a philosophical question. But what makes that case so important and so potentially disruptive to what people think of when they think of Roe v. Wade, which is the woman's right to make the choice to have an abortion, is that in the absence of the viability standard, we don't know what would be a constitutional basis for restricting states and what the lines that they could draw in determining when women are permitted or can lawfully be prohibited from having an abortion. So in the opposition to the request for the court to review the case, the proponents of the pro-choice advocates were very, very strict and clear that viability is a clear and proper standard. And now I think they have to go back to the drawing board and at least think, what else might there be? Because if viability is going to go by the by, then we don't know what would be put in its place.
Aziz Huq, the court doesn't operate in a vacuum. It's aware of, obviously, of what the political currents are in the country. And at this point, most polls show that most Americans, not necessarily an overwhelming majority, but a majority of Americans do support Roe v. Wade. Does that factor, how do those outside influences impact how a court rules?
Well, the court obviously exists in a political context. Critically, it's appointed by presidents and confirmed by senates that have political considerations in mind. And we would not be seeing the Dobbs case arise and be adjudicated in the way that it will be adjudicated in the absence of the appointments that we've seen in the last few years. However, the kind of present opinion poll data that you cited, I think has an extremely weak, if any, effect upon the court. The court is by design and in the operation of the justices themselves, reasonably well insulated from public opinion writ large, the court is much more sensitive to the opinion of political and legal elites.
Let's move on to another case that just wrapped up oral arguments, and this involves a cheerleader who was suspended from the cheer squad for posting profanities on social media after school hours. Joe Morris, how much does the person in question being a student and being off school grounds play a role here?
Well, it's huge. Now, I come down in a fairly libertarian way on this case. We have a prior Supreme Court decision known as Tinker. It involved an Iowa school district, the Des Moines school district, that confers upon school authorities pretty wide range of authority over what happens inside the schoolhouse, the ability to regulate speech and conduct and so forth inside the schoolhouse, if that speech is of a disruptive nature. What's significant about this case is it involves speech that took place entirely outside the schoolhouse. It involves social media. To be clear, the student in question, a young cheerleader who was knocked off her cheerleading squad, said some rather obscene things, not about the school or about other students or teachers involved in the situation, but about the notion of cheerleading and the team and the like in general. She used the F word several times in her statement, not identifying in particular the school insofar as I'm aware of the facts. This is clearly entirely off-campus, out-of-school behavior. And in my view, this is a considerable overreach on the part of school authorities. What is at issue here is a First Amendment right, a right of a citizen, even if a child, to speak in a setting that is not controlled by government authorities.
Robert Hochman, how about that? When one looks at technology and what anybody can say on the internet, is there really such a thing as on campus or off school grounds anymore?
I actually think that's the most interesting aspect of this case, and it might not be limited to the question of disciplining students in a school environment. That's the focus of the case, and I think there's a lot of attention focused on that for good reasons. But the question of social media speech in general, the fact that it takes place both nowhere and everywhere, was very much on the minds of the justices at argument, and that has potential implications in a lot of other areas of law beyond school discipline. There are employment-related implications there. There are public employment and otherwise. And this is something that the court, for the past 20 years or so, certainly since Chief Justice Roberts has been on the court, has really struggled with, sort of adapting old norms and cases and views about privacy and various other rights to the modern internet age. And this, I think, is going to be a significant step forward in that.
Aziz Huq, the court also took up a case involving a California law that requires charities to disclose their donors. Kind of a parallel, do you see a parallel to that in cases involving political contributions? Expand on that.
Well, the Supreme Court has struck down both federal and state laws that limit the expenditures and contributions that people can make either to political parties or to political candidates. In doing this, the court has repeatedly underscored that campaign finance regulation that concerns money is not necessary because states and the federal government can impose disclosure regulations. This was, for example, an important part of the Citizens United decision. The decision, or the case that's before the court, concerns California's requirement that charities give to the California Attorney General a part of their federal tax return that discloses their major donors. The worry that has been expressed by the state of California and by the federal government in respect to this case is that a decision that protects donors to a charity will be extended to disclosure rules that have previously been upheld in the campaign finance context, such that the justification for limits on expenditures and contributions will fall away. The state, that is, will be unable to regulate campaign finance directly, and it will be unable to use disclosure mandates to ensure that we, the citizens, understand who stands financially behind a party or a candidate.
Three tantalizing decisions. Maybe we'll have you back when those decisions are actually issued. Gentlemen, thank you so much. Robert Hochman, Aziz Huq, and Joseph Morris.
Thank you.